Judgment in the appeal beginning on the application of the Electoral Commission against City of Westminster Magistrates Court and the United Kingdom Independence Party.
In the year 2000, Parliament, for the first time, passed an act that placed restrictions on the donations that could be made to political parties. The Political Parties Elections and Referendums Act provided that a registered political party could only accept a donation from an individual if that individual was on an electoral register. Donations received from a donor who did not satisfy that requirement had to be returned within 30 days. If they were not, the Magistrates' Court was given the following power. The Court may, on an application made by the Commission, order the forfeiture by the party of an amount equal to the value of the donation. Between the 1st of December 2004 and the 2nd of February 2006, the United Kingdom Independence Party, UKIP, received a series of donations amounting to nearly £350,000 in total from a member of the party called Alan Bown, whose name was not on an electoral register. The Electoral Commission applied to the senior district judge for the forfeiture of the entire sum. He declined to make such an order, but ordered the forfeiture of only £14,481. His reasoning was as follows. The object of the legislation was to prevent foreign donors from funding political parties. The test of entry on the electoral register had been adopted as a simple test to ensure that foreign donors were excluded. Mr. Bown was not a foreign donor. He was entitled to be entered on the electoral register. He'd been omitted by an oversight. In these circumstances, forfeiture of all his donations was not appropriate. Forfeiture should be restricted to the period when UKIP had been aware that he was not on the register. This produced the sum of £14,481. The Court of Appeal held that the senior district judge had erred in principle. Parliament had outlawed donations from an impermissible donor, being a donor not on the register. Such donations should never have been received by UKIP. Accordingly, they ought to be forfeited in the absence of exceptional circumstances. There were no such exceptional circumstances on the facts of this case. 3 members of this court agreed with the Court of Appeal. The majority, however, agreed with the senior district judge as to the governing principles, albeit that his reasoning did not deal adequately with all the points that had been argued. The history of the Act showed plainly that its object was to prevent funding by foreign donors. Where the donor was not on an electoral register, there should be a presumption that he was a foreign donor and that his donation should be forfeited. If, however, the party could demonstrate that the donor was entitled to be entered on the electoral register so that his donation was not from a foreign donor, the presumption that the whole of his donation should be forfeited was rebutted. In such circumstances, the extent of forfeiture should reflect the degree to which the party had been at fault in accepting the donation in breach of the Act. On all the facts of the case, the result reached by the senior district judge fell within the boundaries of the forfeiture that was appropriate, and his order should be restored.